Okay, very brief intro. Kristi talked yesterday. Kristi's an awesome lawyer from Minter, Ellison in Brisbane, also sits on the Royal Brisbane Ethics Committee and was senior counsel at QIMR Berghofer, and is uniquely placed to talk about uses of health data, the intersection of legislation and practical considerations. Over to you, Kristi. You're muted, by the way.
Okay, that should be working now. Can you see my screen and hear me okay?
Perfect, thank you.
Thanks, Gordon. So I'll try to keep to time as best I can because I know we're running a little bit late, but I have been asked to talk about privacy in research. So the intersection of regulation and practicality, which is obviously very important for HRECs. And I apologise to anyone who has sat through this talk or a variation of it. It is similar to the talk I gave last year at the HREC Chair gathering, and also some of the HRECs that we've presented to throughout the year. Okay, so just to summarise then what the regulations are when we talk about privacy, and I did hear in the last talk there was the reference to the fact that there are a number of sources of regulation in Australia, and also when we're looking at medical research there does tend to be that mix of privacy obligation sources, both at the state level, which governs public health records, and also at the Commonwealth level, which governs most independent medical research institutes, and also research which is conducted with Commonwealth funding will usually then import that Commonwealth standard of privacy obligations. So in Queensland, we've got the Information Privacy Act, and that governs Queensland government departments and statutory bodies. So that's hospital health services, universities, Department of Health, and statutory bodies such as QIMR Berghofer will be caught under the Information Privacy Act. And when we're dealing with health information under the Information Privacy Act, it is the national privacy principles that still are the compliance document under that piece of legislation. When we're talking about non-health information, it's the information privacy principles. But generally, when we deal with medical research, we are looking at the NPPs because it will involve health information. There are also provisions under the Hospital and Health Boards Act as it relates to hospital and health services, and there's confidentiality provisions in there. And then, as I've referred to further down in the slide, the Public Health Act also governs public health records that in a number of cases you also need to apply under the Public Health Act in order to access public health records. And then we've got the Privacy Act, which applies to everyone else, and some of the above, as I said, when there's Commonwealth funding involved. So this is just a sort of a guide on how you try and work out what the source of the obligation is. So this is certainly not set in concrete. It's just to sort of talk through and offer a pictorial example of the kind of thoughts you need to take, the process that you need to take your thoughts through when you're trying to figure out what piece of legislation applies. So is it a public health facility? If it is it a public health employee we're talking about? Because it might be that the facility is governed by state legislation, but the individual researcher is governed by Commonwealth legislation. And then you've got to look to, well, there's the various obligations that arise in that scenario. Just as a comparative summary to sort of pull out what some of the key differences or similarities are between the various sources. So the NPPs, as I said, that's under the Information Privacy Act in Queensland, the Hospital Health Boards Act, Public Health Act, and then the APPs. So for the collection of information, you can see that it's governed by the NPPs and the APPs, which are consistent that consent is required for the collection of health information, or a waiver of consent, which we'll talk about a bit more later. Disclosure of information is governed under the NPPs. the HHBA and also the APPs. Under the APPs and NPPs, it's for the primary purpose of collection or with under a permitted secondary purpose. But as you can see under the HHBA, the disclosure is only permitted, is only allowed where it's permitted under that Act. There are specific circumstances set out under that legislation. And then use and disclosure of health information. All of them have some varying contribution into that. NPPs and APPs have the waiver of consent process. HHBA does have specific provision there for the disclosure for approved research. And then under the Public Health Act, that's where you do actually need that Public Health Act application. The core principles across all of those regulatory regimes are consistent, and they are also consistent with some international standards, such as the GDPR, the General Data Protection Regulation in the EU, which is becoming a bit more common practice. And I'm currently looking into, for those that aren't aware, the Privacy Act in Australia is under review. There's a review document that has been issued by the Attorney General's Department for submissions onto into how that is actually going to be reviewed and the approach that is going to be taken. So I probably should have started with the disclaimer that this is all based on the privacy regime as it stands now, but over the next 12 months, we may see some changes to that because it is going through a review process at present. I don't expect these core principles will change though, because they are consistent across most privacy regimes. And the first is a consideration of privacy. Privacy by design, that privacy should be a key consideration in all projects, including research proposals, not just something that's a last minute thought, but it's actually a key component in there. Collection of personal information. So governing how information is collected. In Australia, you do need to provide information to an individual when you collect it. It's referred to as a collection statement. So you need to give them information about your identity, what the purpose of the collection is, how you're going to be collecting it, what your usual uses and disclosures are, any consequences of withholding information, and also providing details of a privacy policy. Collection should also be from the individual where possible. And this is something that does pop up quite often in research, that in some cases it's not possible or reasonable to collect from the individual, and there are cases you might need to collect from another entity. What you'd need to look for is why. Why can't you collect it from the individual? Is that a reasonable excuse for not collecting it from the individual? Only what's required for the primary purpose. This is another big issue that arises in research is, I know that proposals sometimes that come through the HREC, it does read like it's a bit of a fishing expedition. You need to be able to relate what you're collecting back to your purpose of collection. That is one of the requirements, and that is quite consistent. And also that you need consent for the collection of sensitive information. So they're the key aspects of the collection of personal information data, and they are relatively consistent across those regimes. Use and disclosure of information. So dealing with personal information or data, again, it's quite consistent that it's the primary purpose. You can use the information for the primary purpose for which it was collected, otherwise for a permitted secondary purpose. And there's a number of permitted secondary purposes. Consent obviously is one, a waiver of consent is another, where there's a reasonable expectation and it's related to the primary purpose, if it's required by law, or if it's necessary to lessen or prevent a serious threat to the life, health or safety of an individual. There are also groupings of principles around the security and integrity of information. There are expectations that once you've got that personal information, you hold it and it's held securely, and you've turned your mind to how you're going to secure that against misuse or loss. And then finally, providing access to personal information. All of the regimes have a scheme by which individuals can request access to their personal information. So quite relevant for HRECs is the waiver of consent. It allows an ethics committee to approve a research project which proposes to collect or use personal information or personal data without consent. So as I said, when you collect health information, you need to do it with consent. And also when you're going to use or disclose for a secondary purpose, you need to have the consent to do that. This provides a mechanisms where researchers can seek a waiver of consent, so they don't have to obtain that consent either to the collection or to the use and disclosure. The key requirements that it's necessary for research. It might seem straightforward, but the OAIC has made a determination in PA and Department of Veteran Affairs that an establishment of a study role or essentially a recruitment database was not medical research. So you do actually need to turn your mind to that one, not just assume because it's the researcher asking that it is relevant for research or necessary for research. It needs to be impractical to obtain consent. I've highlighted that it's impractical, not merely inconvenient. That is something that you need to consider. Also that it needs to be conducted in accordance with approved guidelines. That tends not to be a very big issue as what the other criteria are. I've just got a final point here. It is a threshold issue, but I think it's something that's sort of overlooked sometimes, is that there needs to be, because this exemption is only required in relation to personal information, so that's identified or reasonably identifiable information, there has to be a valid reason that the research can't be done with de-identified information, and therefore that the waiver is actually required. So really that's the thing that you need to be putting your mind to in the beginning is, does it actually need to be identified information that would require a waiver, or can the research be done with de-identified information? So moving then on to de-identification, why it is such a big issue. So there's a legal and an ethical rationale, and both obviously are relevant for HRECs. The legal rationale is that the definition of personal information is information or an opinion about an identified individual or an individual who is reasonably identifiable. So if the information is properly de-identified, they're no longer identified or identifiable, and therefore it's not personal information, therefore the Privacy Act or the Information Privacy Act in Queensland won't apply to de-identified information. So that's the legal rationale. But then there is also the ethical rationale that you de-identify information as far as you can, even if it's still criteria of reasonably identifiable and you do still need to comply. Anything you can do to remove the risk of that being identifiable is something that would be expected under the national statement, and to ensure that respect for participants is there is an interchangeable approach to those unidentified, non-identified, anonymous, depending on the scenario. And I'm sure a number of you have seen research proposals where they are used interchangeably. There is no set definition of what's required for each. And the OAIC, I've got up there, the guidance they give is that if the information is no longer about an identifiable individual or an individual who is reasonably identifiable. So you can see that's not overly helpful. It's a bit of a circular definition. But there is no strict sort of guidelines on what is considered de-identified, what's considered non-identified, and what goes into that stage of anonymous. It is based on a reasonably identifiable spectrum. And anyone that has attended any of my privacy talks, I do pull this out quite often because I think it's a really helpful visual guide to understanding that identification does operate on a spectrum. That it's not just clearly identified or de-identified or anonymous, that it sort of operates along that spectrum. It is also really important that it depends on your audience. So identifiability does often depend on the bigger scheme. It's not just about the one piece of information, but you do also need to consider other pieces of information that might be added to that, or the circumstances of disclosure that might make it identifiable to one class of people but not another, and who are you identifying it to, and what are the protections that it won't fall into the hands of that other class. So just to give some practical examples here about de-identification, because I think it's really helpful to see how this does go wrong and the implications of how it goes wrong. So New York Taxi data, the New York Taxi Company released the de-identified data set. It was just as a fun exercise to allow people to see a day in the life of a New York taxi. However, when that de-identified data set was combined with publicly available information from the media and tabloids showing celebrity location and taxi numbers when they're getting into taxis, it was actually possible to extract from that data details of journeys taken by particular celebrities. Including, as indicated, their attendance at strip clubs, and also revealing information about the tipping practices of Bradley Cooper, who's pictured there. Similarly, the London public bike use data was released for the purpose of public engagement about their bike program, similar to what we've got in Brisbane. Each user has their own unique bike account, and when the data was analysed, so when the de-identified data set was analysed internally and compiled with other publicly available information, it was said to have been capable of revealing individual users' behaviour and also then potentially their identity. Finally, as most of us know, in 2017, the Commonwealth Government released a large amount of de-identified Medicare data, which it was soon realised that was potentially capable of revealing practices of particular doctors and their patients, and the data set was withdrawn. So when looking at de-identification, you do need to think about those other factors of, firstly, how much information is being given, and does that volume of information itself render the information potentially identifiable? Or also, what's missing, and is that missing piece of information to make it identifiable, is that publicly available? So when privacy regulation might not be enough, and this is certainly something, having just gone through the Privacy Act issues paper, it certainly is acknowledging that there are some gaps when we're looking at privacy regulation. And when we're talking about research and medical research, that's when the national statement steps in. It applies to data whether or not it's identified, and it requires that consideration, that ethical review of the participant and of what's in their interests and what is respectful to them about how you use the data. Some specific risk areas where I think the national statement probably is a stronger guidance necessarily than the Privacy Act, which doesn't appropriately deal with it, is in the areas of big data, artificial intelligence, genetics, and future use. So with big data, the issues that we've got in fitting that into the privacy regulation is just the sheer volume of personal information that is being collected, I think really threatens the idea of de-identification or anonymity. It's often an automated collection and processing system. So as to whether or not you can comply with that, the steps of collecting directly from the individual, providing them with a collection statement about that collection, all of those kinds of requirements under the Privacy Act. The secondary purposes and beyond can be hard to define, where data is used in machine learning technology, and that can undermine then the consent model. Prediction and profiling is becoming more commonplace. The Attorney General's Department has referred to that in the privacy issues paper as inferred information, and how do we deal with inferred information? And access and correction of personal information can be difficult, and it can have significant implications when it's been included into artificial intelligence or algorithm technology. If that information is corrected or challenged to be inaccurate, what are the potential implications flowing on if you've used that information to develop an algorithm? Then just quickly on genetic information, the reasonably identifiable, and I don't think we need to go into too much to really highlight that genetic data is becoming more and more reasonably identifiable. Whether it's the information or the sample that's collected, the Privacy Act only protects the information, but arguably the sample also holds the information. It contains information about more than just one individual, and that's another area where individual consent might not be sufficient to actually protect all individuals who are impacted by that. It can't be changed, and it's difficult to anonymise. And then finally, future use. Consent, it's becoming a big issue, particularly because quite often researchers want to be able to use their data in future. The risks are in relation to future use of information collected through research is that consent must be both current and specific. If you're relying on a consent for future use, you really do, it's a subjective, there's no hard and fast rule as to whether and how long that consent will be valid for. It will depend on things like the nature of the original consent, the nature of the proposed future use, and also the lapse of time in between. And the national statement gives some guidance about this and refers to specific, extended or unspecified consent. And when unspecified consent is sought, there is an expectation that the terms will be very clear about the wide-ranging implications of that to potential participants. And also the researchers should turn their mind to whether or not consent for a data registry or a biobank would actually be more appropriate. So that's my very quick crash course in privacy. And I would be happy, I don't know, Gordon, if I've got any time for questions. I know that's a lot to take in a short period of time. But you're muted, Gordon.
That was a wonderful whistle-stop tour, and I have to say the comparative summary slide was really sort of highlighted, I think, a great indication as to what legislation is required and in what circumstances. Kristi, just to confirm then that if one actually had specific consent, or valid consent from the individual, that neither the Privacy Act, Hospital and Health Boards Act, nor Public Health Act would apply?
Yes, that's right, with consent. Yep.
Yeah, absolutely. And Kristi, so obviously ethics committees have on their persons such as yourself as a legal representative. Not all lawyers on a committee would necessarily be conversant with the legislation around the use of research. So therefore, whose responsibility is it to, I guess, determine whether or not it meets these legislative requirements? Is it the ethics committee or is it another entity?
No, it is actually the researcher. It's the sponsor if you've got a sponsor-led investigation project, but otherwise, if it's an investigator-initiated or investigator-led, it would be the principal investigator to make sure that they're compliant with this. I think it's just helpful to understand generally what those privacy obligations are, to understand what those expectations are, and if there's clearly a blatant disparity, then perhaps that's something you should be checking with the researchers, that they have turned their mind to that.
Yeah, and you raised a great point about future use, and I know it's something that most ethics committees will come across and wonder how they deal with it. And I know our modus operandi is to say, well, we're not going to give you non-specific consent for something you're not telling us about. So you're actually going to have to tell the participant as far as possible what you're going to do with their information and how you're going to use it and how you're going to protect it. So, so Kristi, another question, we have perhaps one last question. When a quality activity is being conducted in joint collaboration with universities, so this is a non-research activity, which level of legislation is applicable?
Well, it's not clear who, so universities, I'm not sure who the other entity is.
Let's say between the hospital and the university.
Hospitals and universities, if it's a Queensland university, it will also be bound by the Information Privacy Act. So you'd be applying the Information Privacy Act provisions there. Depends on whose data it is. If it's the hospital's data, you would also need to consult with the HHBA. And if it's identifiable, you might also need to obtain a Public Health Act approval to obtain that information from that public hospital.
Well, if it's, and just to point out, as a quality activity, certainly there are provisions within the Hospital and Health Boards Act, Section 150, for the use of information which can be used for the monitoring, planning, evaluation, and something else of the health system. So I think there are provisions in that Act for the use of certain information, but as you point out, in research contexts, there are other legislation. Kristi?
If you're collaborating with a university and an external entity, it's considered to be a disclosure to that entity if it hasn't collected it. So if you've got health information and you're collaborating with another entity, you've got to satisfy that it's a lawful disclosure.
Someone, I won't say who, has just asked, are private universities incorporated, are they affected by Commonwealth legislation?
I haven't looked. I'm quite sure they are under Commonwealth legislation, the private universities. It just depends on whether they're caught. Actually, they would be, because they're not a statutory body. So it'd be under the Commonwealth. As I said, they are relatively consistent. An exemption you'll find in one, it might be slightly worded differently in another. But it's also following the path of the information as to how it was collected and what regulatory obligations attached to that in the first instance.
Yeah. So thank you, Kristi. That was a wonderful presentation, very consistent with what we heard. I think probably what you were talking about the other day as well. And we had a wonderful talk yesterday from Brent Richards about artificial intelligence and machine learning and the use of data. And I think it does highlight that the privacy legislation needs to be modified to consider all of these future uses of big data.
Yeah, and I will just say to everyone, now is the time. There are submissions open, and certainly those kinds of issues, the Attorney General's Department is open to submissions on those. You've only got 1 week though, quite a quick turnaround.